We have with us this morning Commissioner Chairman Roberts. We have Commissioner Parr. We have Commissioner Gavin, Commissioner Norton. I saw one of our newest commissioners, Commissioner White, and we got Commissioner Levy. And with staff, we have Director Shaw. I think I saw staff Woodson back there. Attorney Matthew Reddish.
All right.
Trying to get it right. And we also have staff Jason Gilliam. I think I see Marsha Sheldon. We have some new staff people, Taylor Wesley and Amber Ryder. And I see Commissioner Fox in the rear, and I see Commissioner Webb and brother. I see Commissioner Schaefer back there, Schaefer Vaughn. And I see Bob Weaver and a host of other guests that I don't know the name of. So with that said and done, Chairman Roberts and Attorney Reddish, we're going to get started.
All right, the first thing I think we need to look at on the legal report is under representations. Has everybody had a chance to read through the legal report? The first
before we go to the presentation, case number 64. Can you pull that up right quick? Number 64 2015020491. Commissioner Norton had a question in regarding that case, so I'm going to give him an opportunity to share with the staff his concern.
Thank you. Commissioner Norton here. The question was, the investigation revealed there's a bill of sale stated as is, no warranty. However, there was a third warranty provided. My understanding is disclosure of the bill of sale as is form requires you to state your position, whether you, the dealership, are providing a warranty or not. And it's unclear in the summary whether that's the case. A third-party warranty does not require the dealer to declare there's a warranty. So I'd like some clarification on this case.
The bill of sale stated as is, no warranty, and right to the side of it, they were clearly sold a warranty through the dealership. And then a lot of issues have come up regarding that warranty because the third-party warranty they did sell overlapped with the manufacturer warranty. And in review of the documents, we felt that it was at its base misleading to say there's no warranty on this vehicle when there were actually two warranties attached on it. But I'm not sure of the exact statute.
Well, I wasn't sure that would the bill of sale from the dealer would it be the same as the as is form, the federal form? Would those two have to be the same?
There was no federal form required on this because it was a semi-truck.
Oh.
And what I went back to at the base was it just being, like I said, at its base, I thought it was misleading and deceptive to put no warranty on a bill of sale when you actually did sell somebody a warranty. And it was listed right to the side that there was a warranty sold, and there was no mention anywhere in the paperwork about the manufacturer warranty. And basically the warranty they sold them was completely unnecessary. There's no benefit gained from it. And so I chose to put it on the legal report as one deceptive act. But if the commission feels otherwise, then that's why we have this meeting. We can amend it.
Yeah, so the semi truck is not required to have a disclosure for as is?
There's no requirement for a buyer's guide on, I think it's a Class 8 vehicle under federal FTC laws.
Not familiar with that, but
I had to look it up myself.
I just knew it just looked odd because the dealer can sell the vehicle if his position as is, no warranty, and there can be a third-party warranty involved. A third-party
they
contract.
sold the warranty themselves. They collected the money on it. I assume the dealership received a share of the funds from selling that warranty. So to say that there's no warranty from the dealer, I mean, they clearly sold them a warranty.
The dealer actually owned the warranty company?
I don't think they own the warranty company, but I believe that they would. I don't know the exact makeup of their contractual agreement with the company offering the warranty, but the dealership would cover the warranty work. And I would assume that, I believe it was $1,000 insurance or warranty policy that they gave them. At least a share of that $1,000 would have gone back to the dealership from how I understand these kind of third-party warranties work. So the dealership sold them the warranty. The dealership had to do the warranty work for them. So, as I said, I just think it's deceptive to say there's no warranty on the bill of sale, especially when there's no requirement for a buyer's guide. Nowhere in the paperwork did it lay out what warranties were being purchased by the consumer. And they're actually only able to get a copy of the third-party warranty they purchased after several weeks of communicating with the dealership and running into several issues. The dealership didn't even want to provide the third-party warranty they gave them. I'm not sure why. I would think probably because it doesn't look good to sell somebody a warranty that covers the exact things the manufacturer warranty already covers. So there's kind of just a lot of strange things that went on with the paperwork on this deal. And the easiest way I felt to penalize them was to find the bill of sale as deceptive.
Understood.
Thank you.
Thanks.
Welcome.
More question regarding? Okay.
Would we want anybody like to amend that entry?
No.
Okay. Are there any other questions before we go to the representation discussion?
That was it. That was it.
Okay. First entry on representations. This is a dealership who hired a former salesperson from Nashville Motor Cars. There are conflicting statements from the dealership as to whether they were aware of the salesperson's role at Nashville Motor Cars and whether or not they had gotten in trouble at Nashville Motor Cars. They originally told the investigator that they were aware. They'd heard through the grapevine. And then later on, when they met with us in our office, they stated they weren't maybe as aware as they told the investigator about the salesperson's role at Nashville Motor Cars. Upon hiring the salesperson, they did not have him licensed in the name of the dealership. During my meeting with the owner of this dealership, he stated it was because he got on verified TN and saw that he did still have a valid salesperson's license, albeit in the name of the dealership, who we summarily suspended a month earlier. The salesperson worked there for several weeks before the commission. I believe an investigator caught wind that this individual was working at Nashville Motor Cars. We found that he sold 5 motor vehicles at the dealership. And then in the October, he sold 5 vehicles before we found him.
500.
No, 5.
Oh, 5, okay.
He sold 5 vehicles before we got an investigator down there. Upon the investigator arriving, making the dealership aware that the salesperson in question did not have a valid salesperson's license, he was terminated from the dealership. In October, the commission voted to assess a $7,000 civil penalty. That consisted of $1,000 per car sold, as well as a $2,000 penalty for employing an unlicensed salesperson. And I believe that we considered it to be somewhat of an aggravating factor that such a well-publicized case, and the salesperson in particular being somewhat publicized in his role at Nashville Motor Cars. Reason for the slightly higher penalties on this case. When the owner of the dealership came to speak with myself and Ms. Shaw and Tony Glandorf, he just asked that we review this penalty in light of the fact that he does not have any prior issues with the Motor Vehicle Commission and has a long history of good behavior.
This Commissioner Jackson, I also saw in most of our report, we were charging, not we were charging, but the fee was $500, and I noticed for the unlicensed, you charge, the staff charge $1,000 versus
correct.
the $500. And then also for the employing of the unlicensed health person, we normally been charging $1,000, but I see where we charge $2,000.
That's correct.
Okay. So I want to make a suggestion, if there's any more discussion, any comments, I think we ought to reduce the 1,000 to 500, be 5 times 500, which would be 2,500, and the 2,000 reduce it to 1,000.
All right.
A question about a rule for that. Do we have a rule for some period of time that someone could be employed as a salesperson until their license comes back?
At a minimum, they need to apply for a license the day they begin, or the day that they're hired.
This one applied for it all?
It was not.
So it, okay.
No salesperson's license was ever applied for, and it would not have been granted if they had.
What would be the total amount?
It will be 3,500 total at this point.
All right.
What paperwork y'all looking at?
It's the first case, no representations. Oh. It's the case number 1 on representations, it's on page 27. Commissioner Jackson, do we need a motion for that?
Yes.
I make a motion that we adjust the fee,
Total 3,500.
total 3,500, yes.
Do I have a second?
Second.
All by saying aye.
Aye.
Ayes have it, so ordered.
All right, there are 183 total cases on the legal report. After discussing the two that we've discussed, does anybody have any further questions? Has everybody had a chance to read all 184 entries?
Yes, yes.
Anyone have any question, any more comments on the report?
Questions here?
Chairman Roberts, you have any? Since we don't hear any other comments, we need a motion to adopt the report based on the adjustment, correct?
Yes,
Subject to the full commission.
correct.
Okay. Do I have a motion?
Motion to adopt.
Second.
All those in favor of the motion signify by saying aye.
Aye.
Ayes have it, so ordered. There's nothing else. We need a motion to close the meeting.
Make a motion to close the meeting. Commissioner Norton?
Second.
All those in favor of the motion signify by saying aye.
Aye.
Ayes have it, so ordered.
This meeting will begin at 9 o'clock. Thank you, Chairman Jackson.
Thank you, Chairman Roberts.